February 23rd, 2021.
Gentleman from the 51st, Douglas Statler. Lady in the 49th, Douglas Summers.
Thank you, Mr. Speaker. I ask unanimous consent that the further reading of the journal be dispensed with and it be marked as approved as having been read.
Lady in the 49th, ask unanimous consent that further reading of the journal be dispensed with and it be approved as having been read. Are there objections? There are no objections. Introduction of guests. Lady in the 49th.
Thank you, Mr. Speaker. Our doctor of the day is Dr. Tour from Toronto, Canada. If people would make him feel welcome.
Reports of standing committees.
Your Committee on Energy and Manufacturing has had under consideration House Bill 2598, altering the definition of an above-ground storage tank. Reports the same back with the recommendation that do pass that it be referred to the Committee on Health.
Report to be received. Bill will be referred to the Committee on Health and Human Resources.
Your Committee on Energy and Manufacturing has had under consideration House Bill 2493, providing valuation limitations for coal property taxation and clarifying the penalties for non-filers. Reports the same back with the recommendation that it do pass that it be referred to the Committee on Finance.
Report to be received and the bill will be referred to the Committee on Finance.
Originating in the Committee on Judiciary is House Bill 2590, relating to the West Virginia Employment Law Worker Classification Act. It's reported with the recommendation that it do pass.
The report will be received.
Your Committee on Judiciary has had under consideration House Bill 2363, relating to best interests of the Child Protection Act of 2021. Reports back to committee substitute, therefore, with the recommendation that the committee substitute do pass.
The report will be received.
Your Committee on Health and Human Resources has had under consideration House Bill 2616, amend and reporting to the Governor and the Legislature to have information continuously available on the Office of Health Facility Licensure and Certifications website. Reports back to committee substitute, therefore, with the recommendation that the committee substitute do pass.
Report will be received.
Your Committee on Health and Human Resources has had under consideration House Bill 2620, relating to a departmental study of the Child Protective Services and foster care workforce. Reports back to committee substitute, therefore, with recommendation that the committee substitute do pass.
The report will be received.
Your Joint Committee on Enrolled Bills has examined, found truly enrolled, and on February 23, 2021, presented to His Excellency the Governor for his action, committee substitute for House Bill 2358, updating meaning of federal adjusted gross income and certain other terms used in West Virginia Personal Income Tax Act, and House Bill 2359, updating the meaning of federal taxable income and certain other terms used in the West Virginia Corporation Net Income Tax Act.
Report will be received.
Your Committee on Education has had under consideration House Bill 2267, establishing an optional bus operator in residence program for school districts. Reports back committee substitute, therefore, with the recommendation that the committee substitute each do pass, and the second reference to the Committee on Finance be dispensed with.
That report will be received. Lady from the 49th.
Thank you, Mr. Speaker. The two chairs have conferred on this matter, and I now ask unanimous consent that the second reference of the bill to the Committee on Finance be dispensed with.
The lady from the 49th asks unanimous consent that the second reference to the Committee on Finance for House Bill 2267 be dispensed with. Does the chair hear objection? No objection is heard. The second reference will be dispensed with. Next report.
Originating in the Committee on Agriculture and Natural Resources is House Bill 2759, relating to tax credit for disabled veterans for lifetime hunting, trapping, and fishing license. It's originated with recommendation that it do pass, that it be referred to the Committee on Finance.
That report will be received. The bill will be referred to the Committee on Finance. Are there further reports of standing committees? If not, reports of select committees. Message from the Executive. Message from the Senate.
The Clerk of the Senate announces the passage by the Senate of Committee Substitute for Senate Bill 1, providing for parity of payment for telehealth services between service in person and service provided through telehealth platform.
The message will be received. The bill will be referred to the Committee on Health and Human Resources.
The Senate has passed Committee Substitute for Senate Bill 12, relating to local health department accountability.
The message will be received. Lady from the 49th.
Thank you, Mr. Speaker. I ask unanimous consent that the bill be taken up for immediate consideration, dispensed with the committee reference, and read a first time.
Lady from the 49th, ask unanimous consent that committee substitute for Senate Bill 12 be taken up for immediate consideration. The committee reference be dispensed with and the bill be read a first time. Does the chair hear objection? No objection is heard. The clerk will read the bill a first time.
Committee substitute for Senate Bill 12 relating to local health department accountability.
The bill will be advanced. Next Senate message.
The Senate has passed committee substitute for Senate Bill 14 providing for additional options for alternative certification for teachers.
The message will be received. Lady from the 49th.
Mr. Speaker, I ask unanimous consent that the bill be taken up for immediate consideration, dispense with the committee reference, and read a first time.
The lady from the 49th asks unanimous consent that committee substitute for Senate Bill 14 be taken up for immediate consideration, that the committee reference be dispensed with, and that the bill be read a first time. Does the chair hear objection? No objection is heard. The committee reference will be dispensed with. The clerk will read the bill a first time.
Committee substitute for Senate Bill 14 providing for additional options for alternative certification for teachers.
The bill will be advanced. Next Senate message.
The Senate has passed Senate Bill 61, expanding coyote control program through voluntary assessment of breeding cows.
The message will be received. The bill will be referred to the Committee on Agriculture and Natural Resources, then the Committee on Finance.
The Senate has passed committee substitute for Senate Bill 244, making it unlawful for public utility to prohibit customers from hiring contractors to construct, install, or maintain connections to public utility.
The message will be received. The bill will be referred to the Committee on Technology and Infrastructure, then the Committee on the Judiciary. Are there further Senate messages? If not, resolutions.
House Concurrent Resolution 10, James Big Jim Schaefer Memorial Bridge.
Lady of the 49th.
Thank you, Mr. Speaker. I ask unanimous consent that the further reading of resolutions introduced be dispensed with and that each resolution be considered as formally introduced and referred to the appropriate committees as indicated on the delegate console system.
Are there objections? There are no objections. Petitions, motions, bills introduced.
House Bill 2717, assure West Virginians proper access to water and sewage service at reasonable rates.
Lady of the 49th.
Thank you, Mr. Speaker. I ask unanimous consent that the further reading of bills introduced be dispensed with and that each bill be considered as formally introduced and referred to the appropriate committees as indicated on the delegate console system.
The lady from the 49th asks unanimous consent that further reading of bills introduced be dispensed with and that each bill be considered as having been formally introduced and referred to the appropriate committees as shown on the delegate console system. Are there objections? There are no objections. Unfinished business. Bills on third reading.
Committee substitute for House Bill 2094 relating to the juvenile restorative justice programs.
Are there objections to having the bill explained in lieu of having it read? There are no objections. Lady from the 38th, Graves to explain the bill.
Thank you, Mr. Speaker. The bill in front of you for your consideration expands on the currently operating restorative justice programs in the state. It does require that participation in the program be voluntary for both offender and most especially for victim. And it also does now require that an offender can only complete a restorative justice program and have his sentence or her sentence dismissed one time. That's the bill for your consideration, Mr. Speaker. I urge passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to passage of the bill? If not, then the question is, shall the bill pass? Those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? The clerk will close the machine and ascertain the result. On that question, there were 99 ayes, 0 nays, and 1 member absent and not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2094 relating to the juvenile restorative justice programs.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
House Bill 2184, increasing the penalties for exposure of governmental representatives to fentanyl or any other harmful drug.
Are there objections to having the bill explained in lieu of having it read? There are no objections. The gentleman of the 35th, Delegate Capito, to explain the bill.
Thank you very much, Mr. Speaker, and good morning, everybody. The bill before you increases the penalties for exposure of government representatives to fentanyl or any other harmful drug. Over the past 5 years in West Virginia, unfortunately, we've seen a trend of increased volumes of these very dangerous drugs into our state and into our communities. And the steady increase has resulted in exposure to some of our hardest working West Virginians, and those being our government representatives, our healthcare providers, utility workers, law enforcement officers, correctional employees, and emergency medical service personnel. In West Virginia alone, there have been numerous police officers and correctional officers exposed to fentanyl while working in their capacity. We've probably seen it in the headlines. And just the smallest amounts of these dangerous drugs can send our law enforcement officers or our first responders to the hospital and can result in serious harm. So what this bill does, it responds to that problem. We don't take lightly in this body or in the committee where this bill came from increasing penalties, but when it affects our first responders and our law enforcement, we certainly do. Misdemeanor, if the exposure of that drug to the class of folks that we enumerate in this bill, if there's no injury. But if it does result in injury of the enumerated class of folks, the protected folks under this bill, it's a felony, punishable from 2 to 5 years and a possible fine of up to $2,000. Mr. Speaker, I urge passage of the bill, and I'm happy to take questions.
The question before the House is, shall the bill pass? Are there members who wish to speak to passage of the bill? The gentleman at 36, Doggett Rowe, is recognized.
Yes, if the gentleman would answer
Certainly.
a few questions. Okay, as I understand it, the misdemeanor is just exposing but no injury to the provider.
Correct.
Now, to be guilty of the misdemeanor, all you have to do is to have possession of the drug and in some way expose. There's no intent to expose. It's just that the person gets exposed.
Well, I would submit that this is not what we call a strict liability crime in the sense that there's a little bit of a hybrid here. The individual, the person, has to unlawfully and intentionally possess this substance, and that intentional and unlawful possession results in exposure.
Okay, so on the misdemeanor, if they just have the drug, now do they have the drug in pill form or in hypodermic needle form? Does it matter?
It's not defined here. It wouldn't matter.
Do you know which these drugs commonly are used? In what form they're commonly used? Would it be hypodermic?
It's my understanding it's usually either liquid or powder.
Okay. And the felony is if the person is not only, the responder is not only exposed, but is injured by the person's electing to have the illegal drug.
Correct.
Okay. All right. Are there any other statutes that would cover this sort of activity, not perhaps as specific, but any other criminal statutes that would cover this same behavior?
No.
And it says fentanyl or any other harmful drug or chemical agent. So it could be any sort of toxic chemical.
We had discussion on this in the committee, and the gentleman's reading is correct, but we felt, and the committee felt, that leaving it somewhat broad with judicial discretion was probably appropriate, because what we're seeing, unfortunately, are derivatives of, especially fentanyl. We're seeing, derivatives of that drug, and we're seeing other harmful substances, small amounts of which can cause injury.
I get the impression that we're trying to get at illegal drug use, but it appears that both the misdemeanor and the felony statute expand that to any toxic chemical that a person might have in any form, would create misdemeanor liability for exposing someone to such a chemical.
It's possible.
Thank you, sir. Thank you, Mr. Speaker.
Are there other members who wish to be recognized on the bill? The gentleman at 37th, Dr. Pushkin, is recognized.
Thank you, Mr. Speaker. Will the chairman continue to yield?
Yes.
Just to follow up on something my other friend from Kanawha asked, there does not have to be intent in any part of this. That's not an element of any part of this bill, right? Intent?
Well, the person that possessed the drugs had to unlawfully and intentionally in the first place possess them. So if you possess the drugs and you did so and you were neither unlawfully nor intentionally possessing the drugs, you couldn't be guilty of this.
The part about intent, you don't have to intentionally expose somebody to it.
Correct.
Because a lot of times people don't know that's what they even had, correct? They buy one thing and they get another. Well, we heard that in questions from counsel in committee.
It's possible. But then I think it's possible also that would go to the intent, depending on what the drug was.
Okay. Thank you. Can I briefly speak to the...
Yes, the gentleman is recognized.
You know, in introducing the bill, my other friend from Kanawha, the chairman, said we've seen a rise in the use of drugs like fentanyl, carfentanil, over the past few years. I just want to remind the body, and especially for new members, we've greatly increased the penalties and sentences for possession and possession to intent for those particular substances. And the deterrent did not work. Once again, this deterrent will not work. This is an extra charge we'll be adding on for somebody, whether they intentionally leave a substance out or not, and someone's exposed to it. So I don't believe it'll work. And once we've heard many times in here, and I believe it, that we should reserve prison for the people that we're afraid of, not the people we're mad at. This is a bill for people we're mad at.
The gentleman, the 17th, Dr. Rohrbach.
Speaker. Sponsor of this bill, I'm going to stand up and defend it just a second. And I'm going to refer back to exactly who this bill is geared at. Now, we just heard that it's geared at putting more people in prison. I'm going to take difference to that. I think who it's geared at, and I'm going to read to you here. Government representatives, i.e. law enforcement, healthcare worker, utility worker, emergency service personnel, correctional employment, or an enforcement officer. What this bill is meant to do is to put an extra layer of protection on the folks that are trying to protect each and every citizen in the state of West Virginia. So to my colleague from Kanawha, I don't think this bill is about putting more people in prison. I think this bill is about protecting the people that stand and protect each and every one of us every day, and I hope the members of this body will support our first responders with this bill with a yes vote. Thank you, Mr. Speaker.
The gentleman, the 36th, Doug Rowe.
Yes, to speak briefly on the bill, I think the bill's really broad. I think it goes much beyond its intent. I think the intent is very good, but I think it goes much broader than that. It doesn't have to be a drug that's being used illegally. It can be any toxic substance, any at all. We've got a tank bill that's coming through where we're dealing with toxic substances. Does that apply? You know, I mean, this is a very, very broad statute that I don't think has any parameters so that people understand clearly what the duties are in regard to any toxic agent. I think those words may be used. It's just so broad. We need to tailor criminal statutes to the specific illegal activity that we want to punish. And in this case, I don't think that this statute does, so I'll be voting no. Thank you.
Does the gentleman, the 35th, Doug Capito, wish to close debate on the bill? If not, the question before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there were 89 ayes, 11 nays, and 1 member absent, not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 2184, increasing the penalties for exposure of government governmental representatives to fentanyl or any other harmful drug.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Are there further bills on third reading? If not, bills on second reading.
Committee substitute for House Bill 2372 allow pre-candidacy papers to be filed the day after the general election.
Are there amendments? If not, the bill will be advanced. Are there further bills on second reading? If not, bills on first reading.
Committee substitute for Senate Bill 11 declaring work stoppage or strike by public employees to be unlawful.
The bill will be advanced.
House Bill 2265 relating to collaborative pharmacy practice and updating rulemaking authority.
The bill will be advanced.
Committee substitute for House Bill 2290 initiating a state employment first policy to facilitate integrated employment of disabled persons.
The bill will be advanced.
Committee substitute for House Bill 2529 prohibiting West Virginia institutions of higher education from discriminating against graduates of private, non-public, or home schools by requiring them to submit to alternative testing.
The bill will be advanced. Are there further bills on first reading? If not, leaves of absence, introduction of guests, miscellaneous business. If not, Lady from the 49th.
Thank you, Mr. Speaker. I move, subject to announcements, that the House adjourn until 11 a.m. Thursday, February 25th.
The lady from the 49th moves that, subject to announcements, the House stand adjourned until 11 a.m. tomorrow. Are there announcements? Lady from the 49th.
Thank you, Mr. Speaker. A reminder that the House will meet today at 4:30 for the purpose of remarks by members. And secondly, your Committee on Rules will meet at 10:45 tomorrow morning, Thursday, February 25th, 10:45 Judiciary Committee Room.
Gentleman of the 10th. I got Chris.
Thank you, Mr. Speaker. Your Committee on Finance will have a budget hearing tomorrow morning, February 25th, in the House chamber at 9 a.m. with the Department of Environmental Protection. Thank you, Mr. Speaker.
Gentleman the 32nd. Doug Fast.
Thank you, Mr. Speaker. Your Committee on Judiciary will meet tomorrow morning at 9:30. 9:30 tomorrow morning, Government Organization Room. The agenda will be posted.
Gentleman the 13th. Doug Higginbotham.
Thank you, Mr. Speaker. Your Committee on Education will meet here in the House of Delegates on tomorrow at 1 p.m. in the House chamber. The agenda will be posted. Additionally, Republican members of the committee will caucus today upstairs in the chairman's office at 12:30. Republicans caucus today, committee tomorrow.
Gentleman the 15th. Doug Foster.
Thank you, Mr. Speaker. Your Committee on Government Organization will meet tomorrow at 3 p.m. and in the Government Organization Committee room, and the committee members, Republican committee members, will caucus 30 minutes before at 2:30 in the chairman's office.
Gentleman the 17th, Doug Rohrbach.
Thank you, Mr. Speaker. Your Committee on Health and Human Resources will meet tomorrow, and this is a time change from the usual time, 1 p.m. in GovOrg, not 3 as usual, but at 1 p.m. tomorrow on Thursday in GovOrg. Thank you, Mr. Speaker.
The gentleman the 63rd, Doug Hardy.
Thank you, Mr. Speaker. Your Committee on Political Subdivisions will meet today at 2 o'clock in the House chamber.
Gentleman the 22nd, Doug Maynard.
Thank you, Mr. Speaker. Today, Infrastructure and Technology will meet here in the chamber at 3 o'clock. That's Infrastructure and Technology here at 3 o'clock.
Leading the 52nd, Doug Seipold.
Thank you, Mr. Speaker. Your Committee on Seniors, Children, and Family Issues will meet today at 1 o'clock in the Government Organization Room. Today at 1 o'clock. Thank you.
Gentleman the 46th, Doug Burkhammer.
Thank you, Mr. Speaker. The Faith First Caucus will be meeting tomorrow morning, Thursday, February 25th at 8 a.m. in the McManus Room, which is room 252.
Gentleman the 44th, Doug Hanna.
Thank you, Mr. Speaker. Your Committee on Prevention and Treatment of Substance Abuse will meet today at 2 p.m. in the Government Organization Room. The agenda is posted.
Gentleman the 7th, Doug Barnhart.
Thank you, Mr. Speaker. Your Committee on Workforce Development will meet today at 1 p.m. here in the House chamber, and the agenda should be posted.
Lady in the 52nd, Doug Seipold.
Thank you, Mr. Speaker. And I needed to also say you need to bring your computer to the meeting today at 1 o'clock with seniors, children, and family issues. Thank you again.
Are there further announcements? The gentleman, the 28th, Edgar Cooper.
Thank you, Mr. Speaker. Your Committee on Homeland Security and Veterans Affairs will meet at 3 o'clock today. The agenda has been posted. Thank you.
Further announcements? If not, question before the House is the motion by the lady from the 49th that the House stand adjourned until 11 a.m. tomorrow. Those in favor will say aye. Those opposed will say no. The ayes have it. The motion is adopted. The House is adjourned until 11 a.m. tomorrow.
Senate will come to order. All those not having privileges of the floor will please vacate the chamber. Those in the gallery and those on the floor will please rise or be led in prayer by Jeff Branham, Senate doorkeeper. Please remain standing after the prayer as the senator from Ohio leads us in reciting the Pledge of Allegiance. Mr. Branham.
Thank you, Mr. President. Please bow your head for a word of prayer. Dear Heavenly Father, thank you for the honor and the privilege to serve in the West Virginia State Senate. Thank you for the many gifts and blessings which you bestow upon us. If it would be your will today, please lead, guide, and direct each senator and Senate staff member in carrying out their duties and responsibilities. Thank you again for blessing us. We pray these things in your name, honor, and glory. Amen.
Thank you. Senator from Ohio.
Please join me in reciting the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Reading of the journal.
West Virginia Legislature Senate Journal, February 23, 2021. The Senate met at 11 a.m. Senator Blair, Mr. President, in the chair.
The senator from Wyoming requests unanimous consent that further reading of the journal be dispensed with and the journal be approved. Is there objection? Chair hears none. Further reading of the journal is dispensed with and the journal is approved. Introduction of guest. Senior Senator from the 17th.
Thank you, Mr. President. It is on behalf of the Senate your pleasure and mine to introduce our doc of the day. In the rear of the chamber, we have with us Dr. Gurjo Tor. If you wouldn't mind standing, let the Senate give you a warm welcome.
Senator from Lewis.
Thank you, Mr. President. I believe it's the South Gallery here as my dad, C.J. Martin, if the Senate would make him feel welcome.
Further introductions. Communications from the House.
The Clerk of the House announced the passage by that body of committee substitute for House Bill 2260 relating to procurement of child placing services.
The message will be received and the bill will be referred to the Committee on Health and Human Resources.
House Bill 2500, create an act for statewide uniformity for auxiliary container regulations.
The message will be received and the bill will be referred to the Committee on Governmental Organization.
Committee substitute for House Joint Resolution 1, Education Accountability Amendment.
The message will be received and the resolution will be referred to the Committee on Judiciary and then to the Committee on Finance. Communications from the Executive.
There are none.
Reports from standing committees.
Your Committee on Military has had under consideration Senate Bill 16, providing continued eligibility for developmental disability services to dependents of military members, and reports the same back with the recommendation that it do pass, but under the original double committee reference, first be referred to the Committee on Finance. Respectfully submitted, Ryan W. Weld, Chair.
The report will be received. Senior Senator from the 4th.
Thank you, Mr. President. I ask unanimous consent to dispense with the second committee reference to the Committee on Finance. The fiscal note from the Department of Homeland Security indicates this bill has no financial impact.
Is there objection? Chair hears none. So ordered.
Your Committee on Health and Human Resources has had under consideration Senate Bill 39, prohibiting insurance coverage from requiring prior authorization for tests to stage cancer, and reports the same back with the recommendation that it do pass, but under the original double committee reference, first be referred to the Committee on Finance. Respectfully submitted, Michael J. Maroney, Chair.
The report will be received, and under the original double committee reference, the bill will be referred to the Committee on Finance.
Your Committee on Education has had under consideration Senate Bill 294, permitting early closure of prepaid tuition trust fund, and reports back a committee substitute for same, with the recommendation that the committee substitute do pass, but under the original double committee reference, first be referred to the Committee on Finance. Respectfully submitted, Patricia Puertas Rucker, Chair.
The report will be received, and under the original double committee reference, the bill will be referred to the Committee on Finance.
Your Committee on Finance has had under consideration Senate Bill 308, modifying requirement that racetrack participate in West Virginia Thoroughbred Development Fund by a certain date, and Senate Bill 358, removing prohibition on ATMs located in area where racetrack video lottery machines are located, and reports the same back with the recommendation that they each do pass. Respectfully submitted, Eric J. Tarr, Chair.
The report will be received.
Your Committee on Transportation and Infrastructure has had under consideration Senate Bill 321, clarifying and updating language regarding Fairmont State alumni license plates, and reports back a committee substitute for same, with the recommendation that the committee substitute do pass. Respectfully submitted, Charles H. Clements, Chair.
The report will be received.
Your Committee on Government Organization has had under consideration Senate Bill 338, creating Fire Service Equipment and Training Fund, and reports the same back with the recommendation that it do pass, but under the original double committee reference, first be referred to the Committee on Finance. Respectfully submitted, Mark R. Maynard, Chair.
The report will be received. Senior Senator from the 4th.
Thank you, Mr. President. I ask unanimous consent that the second reference to the Committee on Finance be dispensed. The bill has no financial impact on the state.
Is there objection? Chair hears none. So ordered.
Your Committee on Government Organization has had under consideration Senate Bill 374, increasing threshold for bid requirement to $10,000 to be consistent with other state agencies, and reports the same back with the recommendation that it do pass. Respectfully submitted, Mark R. Maynard, Chair.
The report will be received.
Your Committee on Health and Human Resources has had under consideration Senate Bill 377, relating to extension for boil water advisories by a water utility or public service district, and reports back a committee substitute for same, with the recommendation that the committee substitute do pass. Respectfully submitted, Michael J. Maroney, Chair.
The report will be received.
Your Committee on Government Organization has had under consideration Senate Bill 389, relating to State Resiliency Office responsibility to plan for emergency and disaster response, recovery, and resiliency, and reports back a committee substitute for same, with the recommendation that the committee substitute do pass. Respectfully submitted, Mark R. Maynard, Chair.
The report will be received.
Your Committee on Transportation and Infrastructure has had under consideration Senate Concurrent Resolution 6, naming the U.S. Navy Seaman Second Class Wilbur Webb Hahn and John W. Hahn Memorial Bridge, and reports the same back with the recommendation that it be adopted. Respectfully submitted, Charles H. Clements, Chair.
The report will be received.
Your Committee on Education has had under consideration engrossed committee substitute for House Bill 2012 relating to public charter schools, and has amended same, and reports the same back with the recommendation that it do pass as amended. Respectfully submitted, Patricia Puertas Rucker, Chair.
The report will be received.
Your Committee on Health and Human Resources has had under consideration engrossed House Bill 2262 relating to the Controlled Substance Monitoring Database, and has amended same, and reports the same back with the recommendation that it do pass as amended. Respectfully submitted, Michael J. Maroney, Chair.
The report will be received. Reports from select committees.
There are none.
Introduction of bills. Senior Senator from the 17th.
Thank you, Mr. President. I request unanimous consent that Senate Bill 433 through Senate Bill 443 be considered introduced, read by their titles, and referred to the appropriate committees as shown on the chamber automation system.
Senior Senator from the 17th requests unanimous consent that Senate Bill 433 through Senate Bill 443 be considered introduced, read by their titles, and referred to the appropriate committees as shown on the chamber automation system. Is there objection? The chair hears none. So ordered. Resolutions.
Senate Joint Resolution 10 by Senator Nelson, limiting the terms of members of the House of Delegates amendment.
The resolution will be referred to the Committee on Judiciary and then the Committee on Finance.
Senate Concurrent Resolution 9 by Senator Plymel, naming the Haney Family Veterans Memorial Bridge.
Under the rules of the Senate, the resolution will lie over one day.
Senate Resolution 9 by Senators Caputo and Weld, designating February 25th, 2021 as Fairmont State University Day.
Under the rules of the Senate, the resolution will lie over one day. Motions. Petitions.
There are none.
Senior Senator from the 17th.
Go ahead. Unfinished business. Another mistake I made.
Oh, disregard. Unfinished business.
Senate Concurrent Resolution 8, naming the Fire Chief Kenneth Jr. Russell Memorial Bridge.
The resolution will be referred to the Committee on Transportation and Infrastructure. Bills on third reading.
Engrossed Senate Bill 67, relating to authority of Emergency Medical Services Advisory Committee, Council. Third reading of the bill.
Question is on passage of the bill. Senator from Marshall.
Thank you, Mr. President. Senate Bill 67 requires that the Emergency Medical Services Advisory Council review any proposed rule by the Bureau of Public Health Commissioner for legislative approval and provide a recommendation to the Legislative Rulemaking Review Committee. Their recommendations shall include either authorizing the rule, authorizing part of the rule, authorizing the rule with amendments, recommending the rule be withdrawn, or rejecting the rule. Thank you, Mr. President. I urge passage of the bill.
Question is on passage of the bill. Is there discussion? Senator from Boone.
Thank you, Mr. President. Would the chairman yield?
Would the chairman yield? The chairman yields.
Thank you. Chairman, again, they will review the rules that has to do with the EMS, and they're very close to that system. Is there any obligation that those they have to follow one of those 5 things, either authorize it, reject it, part of the legislative rule? Is there any absolute say that they have versus just make a recommendation?
What's that? No, they just make a recommendation. Basically, this arose because the MSAC, which is the Emergency Medical Service Advisory Council, which has been, from my understanding, although I don't have any real personal experience with it, has been one of these councils that's really done a good job since its origination. And so they like to weigh in on these issues. Well, there's been some rules that have been proposed that have made it to the Legislative Rulemaking Review Committee. And as they're getting ready to, go through that rule in the committee process, it's like, well, what's MSAC thinking? It's like, well, not sure. And then, doesn't matter. So it's just this helps the legislative rulemaking committee make decisions. They can understand both sides of the issue, and I think it's my understanding that the MSAC. Well, they want this. It's like this gives them a voice. It has to be heard, and therefore, the rules will not be approved without them weighing in. That's where this came from, and I think it came from maybe an issue that came up a few months ago.
But they don't have the final say, but they do get to make the recommendation. They're the folks that have the boots on the ground that knows the.
No, this doesn't change anything. The rules are still made the same way. They're still approved the same way. All this does is give them a chance to offer their opinion, or requires them to offer their opinion.
Thank you.
Which is why they're there in the first place.
Thank you, Mr. Chairman. I think it's a good bill, and I urge passage.
Is there further discussion? If not, the question before the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, 34 yeas, 0 nays, 0 absent and not voting. More than a majority of those present and voting have voted in the affirmative. I declare the bill passed. The clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 79, providing fair mechanism for adjudication of requests for relocation of parent with child. Third reading of the bill.
Question is on passage of the bill. Senator from Morgan.
Thank you, Mr. President. The committee substitute for Senate Bill 79 would amend a single section of our state code. It is Chapter 48, Article 9, Section 403. So Chapter 48 is our Domestic Relations Code. Article 9 is the allocation of custodial responsibility and decision-making responsibility for children. And it's in Part 4, which is modification of parenting plans. We have a statute there now, this one section that would be amended by the bill, and the bill substantially rewrites the whole section. And it addresses one particular thing, Mr. President. It addresses when a parent wants to relocate with a child. And so under our current statute, which is fraught with problems, the Supreme Court has determined that our statute that we have now creates a presumption in favor of relocation. And so the purpose of this bill is to rewrite the statute. I'm not critical of the decisions of the Supreme Court that have been made on that statute because I think they're fair interpretations of the statute that we have in place, and our problem is that the statute we have now is flawed. And that's the purpose of this bill, is to fix it. But in two cases, Stacey J. versus Henry A., and then Nicole L. versus Stephen W., the Supreme Court said that the way our statute's written, there is a presumption in favor of relocation. And so this bill will correct that or change it. Under the current law, the law doesn't require a written petition or a hearing before relocation happens. That's the problem with our current law, Mr. President. In fact, while the current law requires notice, our statute doesn't even say written notice. You know, it doesn't indicate, and that language is stricken in the bill. It just says the parent's got to give notice to the other parent. So family court judges around this state have told me they're dealing with cases where a parent says, I never got a notice. And the other parent says, I mailed you a notice. And the family court judges say, well, they may both be telling the truth. But here's, under the bill, the current language is stricken, and what we would be saying is that when a parent's going to relocate, it's a substantial change in circumstances if it impairs either parent's ability to exercise custodial responsibilities that the parent has been exercising, or when it impairs the schedule of custodial allocation that's been in place under a court order. So change in circumstances are magic words in the domestic relations arena, in that area of law. Change in circumstances is what allows a parent to go back in and ask the court to change or modify the orders that have been entered. So what we require in this bill is if a parent wants to relocate, move, then they have to file a petition with the court. And the law would require under Subsection B that the petition be filed 75 days in advance of any relocation. And a summons be served, the court schedules a hearing which would be expedited. The petition has to include the relocation date, the address of the intended new residence, the specific reasons for relocation, a proposal for how custodial responsibility should be modified in light of a relocation or move if it occurs, and a request for a hearing. So the court is required then, the family court, schedule up a hearing, get the parties in there before the court, and what we're making clear in this statute is, as in all cases in domestic relations law, what the court is supposed to do is examine what is in the best interests of the child. That's our standard. That's our polar star. In areas where we give courts discretion to act, the standard is what's in the best interests of the child. And so, Mr. President, in the bill, there are reasons listed for relocation that are presumptively legitimate reasons. So we're not, there is a presumption that applies as to that, and it's in subsection D, subdivision 2. I'll read it. It says, a relocation is for a legitimate purpose if it is to be close to immediate family members, for substantial health reasons, to protect the safety of the child or another member of the child's household from significant risk of harm, to pursue a significant employment or educational opportunity, or to be with one's spouse or significant other with whom the relocating parent has cohabited for at least a year and who is established or who is pursuing a significant employment or educational opportunity. And of course, if it's for a legitimate purpose, a court, the bill will force a hearing, and it's important because without a hearing is the process by which the court determines what the new custodial arrangement or allocation will be. But we give the court the power to say no, it's your reasons are not legitimate, and if you move, I can't stop you from moving to Arizona, but if you do, I'm going to order a reallocation of custody. We have some other subsections in the bill, Mr. President. Subsection E was adopted by the committee. It was an amendment that was offered based on the idea and salient point made by the senator from Wyoming County that we ought to make it clear that if the parties can agree upon a modified parenting plan, they can submit it to the court, and the court has the authority to just summarily order it if all the parties are in agreement. We include provisions on how interviewing or questioning of a child occurs, and we're just cross-referencing there the rules of practice and procedure for family courts. Mr. President, this bill was suggested actually by members of the judiciary, family court judges. And what they're seeing is, in some circuits, some family court cases, under our statute, as we have it now, with the flaws that exist within it, relocations are occurring without hearings, without court orders, and on some occasions it's as simple as a parent saying, well, I've met somebody on Tinder, I've met somebody on the internet, and he's going to get me a job in Louisiana, and I'm taking the kid and going. And so what we're saying is, in this bill, no, let's have the courts look at it, have a hearing, take evidence before that can happen, and determine what's in the best interests of the child or children. Mr. President, I'd be happy to try to answer questions. I urge passage of the bill.
Question is on passage of the bill. Is there discussion? Senator from Cabell.
Thank you, Mr. President. Let me just thank our Judiciary Chair for bringing this before the body. Very timely legislation. For those of you that aren't on Tinder, he mentioned Tinder, which is an online dating app. I won't ask for a show of hands, but I know that a lot of people in our state do find themselves in a situation where these dating sites introduce a couple from different states, and the next morning he or she is ready to take the child to Louisiana or California or wherever. And the procedure that we have as a state currently in our family courts was not set up for that. And basically a goodbye letter might be the end of it. And I just wanted to get up for a minute and just say that this is an example of how our law changes with society, and it's an excellent bill, and I urge passage.
Senator from Boone.
Thank you, Mr. President. Would the chairman of the judiciary yield, please?
Chairman yield. Chairman yields.
Mr. Chairman, again, there looks to be some little bit of latitude given that talks about unless the relocating parent establishes that it was impractical under the circumstances to provide such 75 days notice. Again, there's all kinds of scenarios, I'm sure, but 75 days seems like a long time if there are family emergencies and true things. So there is some latitude in this.
There is. With respect to, it's a great question. We require 75 days, but then, and we require in subsection C, a hearing to be held at least 30 days in advance of the relocation, and that may be the area where the language is that you were talking about. The court shall revise the parenting plan. There is language in here that says if the timelines can't be met, we ask the court to make findings on why, so that it could be reviewed on appeal. And Senator from Boone makes a great point, and that is that every one of these cases has its own unique facts and circumstances. And so our family courts, our judicial system, tries very hard, and I think does a good job on the whole of trying to adapt to and address the unique circumstances of every case. This bill is designed to fix a fundamental problem in the law, which is right now we don't require hearings. We don't require a petition and a hearing, and that's what this will change.
But again, this gives some latitude so that if there was a scenario where there was an emergency, where the parent had to relocate, there would be some latitude so that they could cut that timeline down some. And that's how I read the bill.
It's in, and I think the senator is reading it correctly. It's in subsection B. There's language that says the hearing will be held at least 75 days prior to relocation. Petition filed at least 75 days. Unless, I'm on lines 79 through 81 now, unless the relocating parent establishes that it was impracticable under the circumstances to provide such notice. And, I think that gives the court flexibility and discretion. I would point out, I should have mentioned this earlier, Senator from Harrison County in committee said, what about the other end? And he said, what about a circumstance where someone is offered a job in Kansas to start a year from now, but he or she doesn't want to take the job unless he knows he can or she can take the child with him. So we asked the court to expedite the hearings in here, so that could be a year before. But you got an employer in Kansas who wants an answer. You can be the director of this division of our company, and the employee said, well, I'd love to do it. Putative employee, I'd love to do it. I love to come. I like your company. But, if a court won't let me take my child, bring my child with me, I'm not coming. So we're asking courts, other places in here, to adapt to that circumstance and try to give people a quicker answer by requiring that the court, when necessary, that a person can move for an expedited hearing on that.
Thank you, Mr. Chairman.
Yes, sir.
Further discussion. Senator from Raleigh.
Thank you, Mr. President. As someone who deals with so many families all of the time, a lot more divorce situations than I prefer to ever deal with, I'm very appreciative of the fact that the family court system, who is typically very cold and hard in the mindset of many people, has come forward with some positive suggestions on how they can put the children first. that seems to be a common theme of a problem where people feel like the children are last, and whoever is loudest on one side or the other in a divorce dispute, that creates the problem. And so I would just go on record requesting that the family court system would give us more information on how we can put those children first in those terrible situations, because they need all of the help that they can get and they have very little voice. Thank you.
Further discussion? If not, the question before the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, 34 yeas, 0 nays, and 0 absent and not voting, more than a majority of those present and voting having voted in the affirmative. I declare the bill passed. The clerk has a title amendment.
Senator Trump moved to amend the title of the bill.
The question is on adoption of the title amendment. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the title amendment adopted. Clerk will communicate the action of the Senate to the House.
Engrossed Senate Bill 89, exempting certain kindergarten and preschool programs offered by private schools from registration requirements. Third reading of the bill.
Question is on passage of the bill. Senator from Jefferson.
Thank you, Mr. President. This bill exempts child care licensure requirements from certain educational programs operated by private schools with accredited preschool classes and recognized by the Department of Education. I'm happy to answer any questions. I urge passage.
Question is on passage of the bill. Is there discussion? If not, the question before the Senate is, shall the bill pass? All those in favor will vote yea. All those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, 34 yeas, 0 nays, and 0 absent not voting. More than a majority of those present and voting having voted in the affirmative. I declare the bill passed. The clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 182, authorizing miscellaneous agencies and boards to promulgate legislative rules. Third reading of the bill.
The question is on the passage of the bill. Senator from Morgan.
Thank you, Mr. President. The committee substitute for Senate Bill 182 is Rules Bundle Number 9. It's the miscellaneous rules bundle. It contains 34 rules from various agencies and departments of the executive branch. I will be happy to try to answer questions. Otherwise, I urge passage of the rules bundle.
The question is on the passage of the bill. Is there discussion? If not, the question before the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Tar. We'll wait. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, 34 yeas, 0 nays, and 0 absent not voting. More than a majority of those present and voting having voted in the affirmative. I declare the bill passed. The senior senator from the 17th.
Thank you, Mr. President. I move the bill be made effective from passage and request unanimous consent that the roll call used on passage of the bill be used to make it so effective.
The senior senator from the 17th moves that the bill be made effective from passage and requests unanimous consent that the roll call used on the passage of the bill be used to make it so effective. Is there objection? Chair hears none. On this question, 34 yeas, 0 nays, and 0 absent not voting. More than 2/3 of those elected to the Senate having voted in the affirmative. I declare the bill effective from passage. The clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 270, providing for collection of tax by hotel marketplace facilitators. Third reading of the bill.
The question is on passage of the bill. The senior senator from the 6th.
Thank you, Mr. President. The committee substitute for Senate Bill 270 would require marketplace facilitators, such as Airbnb and Vrbo, to pay the required hotel occupancy tax on behalf of the hotel and motel operators for which they book sales and process payment. The bill makes the facilitator responsible for remitting the hotel occupancy tax directly to either the county commission or the municipality within whose jurisdiction the hotel is located. The bill applies only to marketplace facilitators who have an economic nexus to the state in order to satisfy the U.S. Supreme Court's Wayfair test, which allows state to collect taxes from out-of-state vendors who do not have a physical presence in the state but engage in a specific level of economic activity there. A substantially similar bill completed legislative action last session but was vetoed. This bill addresses the concerns raised in the veto message, in particular the absence of an economic nexus standard in the 2020 bill. I'll entertain questions. Otherwise, I urge passage of the bill.
Question is on passage of the bill. Is there discussion? If not, the question before the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, 34 yeas, 0 nays, 0 absent not voting. More than a majority of those present and voting having voted in the affirmative. I declare the bill passed. The clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 275, relating generally to West Virginia Appellate Reorganization Act of 2021. Third reading of the bill.
Question is on passage of the bill. Senator from Morgan.
Thank you, Mr. President. The committee substitute for Senate Bill 275 is the Intermediate Appellate Courts bill. It is the governor's bill. What I'll do is start by walking through just generally the provisions of the bill. There are changes to numerous sections in the current law, a lot of them in the workers' compensation chapter, and it's just to make clear as to the changes that are occurring in the bill in the appellate process, what happens before, what happens after the intermediate appeals court would be stood up under this bill. The main part of the bill is the Appellate Reorganization Act, and that is a new article in the code, and it would be designated as Chapter 51, Article 11, and it has new sections 1 through 14 new sections of code, which is the new intermediate appellate court. And so let me turn to that, and I'll walk members of the Senate through that. Section 1, the short title is, it refers to the act as the West Virginia Appellate Reorganization Act of 2021. And section number 2 has legislative findings. They're brief. but it makes clear that we're referring to the constitutional authority of the legislature to create an intermediate appellate court, which is found in Article 8 of the Constitution of West Virginia. Section 3, definitions, would define terms: circuit court, clerk, intermediate court of appeals, judge, Supreme Court of Appeals. Section 4, the intermediate appellate court would exist in geographic districts in West Virginia, 2, a north and a south, and that section of the code delineates which counties fall in the north, which counties fall in the southern district of an intermediate court of appeals. Section 5 addresses the jurisdiction of the court. And so this will be similar, Mr. President, to last year's bill in many respects. The Intermediate Court of Appeals shall have original jurisdiction in cases. That's the governor's bill. We changed that. Does not have original jurisdiction in cases of extraordinary writs, mandamus, prohibition, quo warranto, that's habeas corpus. The court has appellate jurisdiction for judgments in civil cases, judgments out of cases arising from circuit court, civil cases, family court after June 30th, 2022. I should say that July 1, 2022 is the date the court would come into existence. So that change, the appeals in those cases would go to an intermediate court of appeals. Final judgments of the circuit court concerning guardianship or conservatorship under Chapter 44A. Final judgments of administrative decisions from administrative law judges entered after that date. So now, Mr. President, those cases go, all of them, to the Circuit Court of Kanawha County. That will change. We'll send them to the Intermediate Appellate Court. Final orders of the Health Care Authority after a certain date. Final decisions of the Office of Judges prior to its termination. This bill terminates the Office of Judges in workers' comp. Final orders of the Board of Review after a certain date. And then we make clear that the court does not have appellate jurisdiction in certain cases. And those are criminal cases, judgments or final orders in juvenile cases, judgments or final orders in child abuse and neglect proceedings, orders of commitment under Chapter 27, Article 5. Those all remain with the Supreme Court and would not be processed through an intermediate court of appeals. Also, final decisions of the Public Service Commission, any interlocutory appeals, any certified questions of law, and all extraordinary remedies provided in Chapter 53. And those are habeas corpus, quo warranto, mandamus, prohibition, certiorari. So we provide in Section 6 a motion, opportunity for a motion for someone to seek a direct review by the Supreme Court. So it says within 10 days after a petition for appeal in the Intermediate Court of Appeals, a party can file a motion to have the case lifted from the Intermediate Court of Appeals to the Supreme Court of Appeals. And we suggest in the statute, the bill, that the court should grant that if both following circumstances exist. One, the appeal involves a question of fundamental public importance. And two, the appeal involves exigencies in which time is of the essence, necessitating direct review by the Supreme Court of Appeals. So an example of that might be, circuit judge has made a ruling as to which candidate is going to be on the ballot. And the deadline's coming up. The ballot's got to be printed and made available. And if you have to process something like that through two courts, it might not be resolved in time. So that would be a kind of circumstance where it might be appropriate for somebody to move for direct review by the Supreme Court and lift it out of the Intermediate Appellate Court. Section 7 addresses the qualifications of the judges for an Intermediate Court of Appeals. They have to be a member of good standing of the state bar. They have to practice law in the state for at least 10 years. They have to be a resident of the state of West Virginia for 5 years prior to appointment or election. Of course, that's a constitutional requirement. Our Constitution requires that judges and senators be 5-year residents of the state of West Virginia. And the judge of an intermediate court has to be a resident of the district. So if you're going to be one of the judges in the north, you got to be a resident in the north. If you're going to be one in the south, you have to be a resident there. And let's see, Section 8. So this is a hybrid, and just to be clear, we've had, in previous years, we had the Senate considered, and I think even passed, a bill that was for an intermediate appellate court that was fully appointed. This is not that. The judges of the Intermediate Court of Appeals would be appointed initially by the governor, both districts, north and south, processed through the Judicial Vacancy Advisory Commission. So people would file applications. The Judicial Vacancy Advisory Commission would vet the candidates, examine their qualifications, make recommendations to the governor, and the governor appoints initially, and he would appoint. And this changed a little bit between judiciary and finance. And I think the way it's come out of the finance committee is he would appoint them all in July 1, 2022, subject to confirmation by the Senate, but then one would stand for election in each of the next successive even-numbered years. One would be elected in each North and South District in 2024, and then I think one in 2026, and then one in 2028. 12-year terms is what the, I think both the Senate Judiciary and Finance Committee settled upon. Section 9 deals with practice and procedure, deadlines. Section 10 talks about the administration of the court, makes it clear in accordance with the state constitution that an intermediate appellate court will be subject to the administration and administrative oversight by the Supreme Court of Appeals. Section 11 addresses reporting of judicial information. Section 12 calls for written opinions by the court and precedential effect of the decisions. And then Section 13 makes clear, and this is consistent with the state constitution, Supreme Court of Appeals, it would have discretionary review over every decision and appeal made by the Intermediate Court of Appeals. And they have discretion to grant or deny a petition for appeal from a decision that's made by the Intermediate Appellate Court. Section 14 addresses compensation. So that changed also between Judiciary and the Finance Committees, and what we had in the bill was actually carryover language from last year's bill, but the members of this body will remember we passed legislation that addressed judicial pay last year, so the salary for intermediate appellate court judges is set midway between, in the bill as it's before us, midway between the salary that exists for circuit judges and the salary that exists for justices of our state Supreme Court of Appeals. Mr. President, this bill, the enactment of this bill is necessary for the future of West Virginia. And I don't want to, I'll give a reasonably full and fair opening here, but I'd like to reserve the right to close debate on this. But it's long overdue. It has been recommended to this legislature for years by legal scholars. It's necessary to alleviate the caseload burdens of the current Supreme Court of Appeals. It's necessary to allow our Supreme Court to spend its time focusing on the development of the law in areas and cases where that is necessary and required, as opposed to its current practice. It's now reviewing every decision that is appealed to it and issuing an opinion. And in my opinion, that is not the most efficient and best use of the considerable talent that we have in the East Wing on our Supreme Court of Appeals. This bill will allow our Supreme Court of Appeals to continue, of course, to handle all the appeals in criminal cases, juvenile cases, abuse and neglect cases, but to work from a discretionary docket on appeals that come out or up from an intermediate appellate court. As I mentioned, and I'll talk more about it later, legal scholars have recommended this improvement in our judicial system, and it will, in my opinion, expedite the appellate process for litigants in West Virginia. We enact this bill, it will speed appeals along because we'll be dividing the docket from family courts and circuit courts. We'll be dividing between the intermediate appellate court and the Supreme Court which cases go where. And I think we'll have people getting appellate decisions under this bill faster than they do now. I think it will speed things along. I think it's, there is some cost with it. Maybe the finance chair will address that. He's certainly more conversant in that than I am. We have fiscal notes on it. But I'd be less than candid if I didn't acknowledge that there is some cost associated with it. But it will be good for West Virginia. It will improve the process by making it quicker for litigants. It will provide our Supreme Court the opportunity to utilize their considerable talents on a discretionary docket in areas of the law that warrant attention and development. And I'm happy to urge for, I think, the 6th time here on the floor of the Senate, the passage of this bill.
The question is on passage of the bill. Is there discussion? Junior Senator from the 8th.
Yes, sir, Mr. President. Thank you. I rise in opposition to the bill. The arguments against the intermediate court bill are varied and fall across the political spectrum. I'm going to focus on 4 particular arguments. The first is this is an expansion of government. And last I heard, and for all the conservatives in this state, I thought that our conservatives were in opposition to an expansion of government. This creates an intermediate court, it creates judges, and it creates their offices and all the staff that they get. Now, I think the fiscal note on this bill is around $7 million to start, and I think it projects to be less than that as it goes forward. And I think in part it's a consequence of the initial judges having to stay in courtrooms or courthouses that are already available, maybe even sharing Supreme Court staff. But as we all know, and I think we can all agree, whether you're conservative or liberal, once you start that, it grows and grows and grows. So that's the first argument against it. It's not conservative. Then you can go on the other extreme of the political spectrum and go to the liberal argument. A week ago, or 10 days ago, I stood up and talked about the millions of more pounds of food our pantries are having to serve West Virginians from last year to this year. We also know, and I think it was the same stat from a year ago, we have at least 10,000 homeless kids in West Virginia. The money it would take to create a court that we don't need, create another layer of government we can use for other purposes that actually address the needs of West Virginians. Third argument is it's impractical. The testimony, first I want to say this. It would be news to me if the Supreme Court wants this in order to unburden their calendar. That was not the testimony on Judiciary Committee. And in fact, I picked up a newspaper today, and the Justice Jenkins was neither for or against the appellate court. So I'm not sure of any information, or I didn't hear any testimony that this court would somehow unburden the work of our Supreme Court. In fact, our Supreme Court works pretty well. There was a time when the intermediate court may have been viable. when people did not have the right to appeal, where appeals were not all appeals were considered by the Supreme Court. That's the argument that I hear all the time about how, well, you know, we need this court because of this reason. Well, the Supreme Court has reformed itself. Everyone has an opportunity to appeal in West Virginia. Everyone gets a decision. Two types of decision. They get a authored opinion if new law is created, or they get a memo opinion if no new law is created because that law already applies to the facts in whatever case is before them. So in West Virginia, we already have the right to appeal. Our Supreme Court already hears all appeals, and those opinions, whether they be written or memo, can be used by litigants in circuit court. In fact, the clerk of the court testified that the Supreme Court has a 109% clearance rate. I don't think there is another governmental entity, state entity, that is that efficient in West Virginia. That means they clear their docket within a year, 109%. We don't need this court. And if I could take issue just real quick, the fourth argument is the legal argument. Who does this hurt? This hurts injured West Virginians. I kind of thought it funny yesterday when I almost laughed on the floor when someone said, in opposition to the amendment brought by the senator from Upshur, that somehow plaintiffs and injured folks already have too many advantages. Well, that's not true. It's the plaintiff's burden to prove the case. They start off with a disadvantage in that regard. They have to go to trial after a year to 18 months. They have to convince anywhere between 6 and 12 of their own peers of the merit of their case. And then they may get, if they get a verdict after that happens, then they may hold on to it. And you think, well, that's strange. Why wouldn't they just get it? The first, and I'm speaking from experience because I've been on this end. I've represented injured folks. I know how difficult it is to get a verdict in West Virginia. The very first call I get from the defense attorney who represents an insurance company is, well, I think you should compromise that verdict. I think you should take less money, because if you don't, I'm going to find something in the trial record to appeal. That's real. That's the mechanics. It does cause delay. The only witness who testified in our Judiciary Committee with appellate experience in other states, meaning in other states that have an intermediate court, testified that in his cases, say in Ohio, having an intermediate court adds another 8 months to the litigation. And the reason why that's important, when you're a civil plaintiff, you're an injured person, you've lost your life, you've lost your wages. It's important for your remedy to come as soon as possible. It won't come as soon as possible if you add this layer, because that's what's going to happen. If you don't take your compromise settlement, we're going to go to the intermediate court. You decide to go ahead and take it to the intermediate court, and then you add another 8 or 9 months if it goes to the Supreme Court after that appeal. The power dynamic hurts the injured folks because the insurance companies have the money. So even when an injured person wins a trial, they don't win. And we're just making it harder for them and creating a system where they get less money. That's who it hurts. It hurts injured West Virginians. And I ask you all, I ask the chamber to oppose this legislation. Thank you.
Further discussion. Senator from Harrison.
Thank you, Mr. President. I think you volunteered me for that, so I'm going to stand up here now. You know, I have to say it again, this is Groundhog Day all over again. I think the senator from Morgan said this is his 7th time for it. This is my 7th time opposing it. But there's a lot to oppose in this bill that we've not seen before. But I want you all to listen carefully, listen to the gentleman from Kanawha who just gave a great rendition of why the Intermediate Court of Appeals is unnecessary. And unnecessary is the key word to all my friends in this chamber.
We're about to waste $7 to $8 million a year, and by the way, the fiscal note's incomplete on the system. It seems to only show the reduction for the workers' comp portion of this bill. But multiply that by 10, just 10 years. I've been here almost 10 years. It goes by in the flash of an eye. That's $100 million. Think what we could do in this state for the opioid epidemic, for hungry children, for education, for our roads. So many more important priorities in the state. I wonder why this bill comes up again and again. Of the 10 states now that don't have an intermediate court, us included, all below 2 million in population. I do not expect this census to give us an increase in population. If anybody else does, maybe you ought to vote for this bill, but our population's going down. But regardless of that, as the senator from Kanawha just said, in 2010, the Supreme Court reformed itself. Every appeal gets an opinion. Every appeal gets consideration. Every appeal is decided on the merits. Now, my senator from Morgan mentioned legal scholars. Those legal scholars, and the big ones, Supreme Court Justice Sandra Day O'Connor, made her views, or reached her views in 2010. In 2008, just a couple years before that, we had almost 4,000 appeals in the West Virginia Supreme Court. Last year, and this number is very critical if you want to make a good decision on this bill, last year there were barely 1,100. 4,000 to 1,100. In 1999, there were 3,600. 2020, 1,100. Every appeal got an opinion. Every appeal was considered by the justices. Every appeal was decided on the merits. Why do we need it? The only reason I can figure out, and I would love to hear how this speeds along appeals, because you're going to have two divisions. You're not going to create any precedent, any new precedent, and precedent's the word we use, the attorneys use for law that's binding that we have to follow, because what you're going to have, you could have two opinions on the same issue coming out of the two different courts that are different. More importantly, as a litigator, I'm going to appeal every adverse decision that happens to me, just like the litigator is on the other side. We're not going to allow the intermediate court to be the final word because we have the opportunity to appeal to the Supreme Court as we do now. I find it interesting that the Supreme Court has not come out in favor of this new layer of government, this new expenditure of taxpayer funds, and said we need it. Why not? I understand why they haven't come out against it. For one, we control their budget. But why haven't they come out for it if it's really going to relieve their workload, if it's really going to benefit the court? Because when you're clearing 109% of your filed appeals in 1 year, you really can't say that you need it. They're clearing more appeals, because appeals take time to mature. Briefs have to be filed, arguments have to be held. Every appeal adds 12 months to the case. You're going to add another 12 months to the case, and it's not just injured people who are going to suffer that delay. It's our small businesses. It's the businesses that have civil litigation that have to go to court because somebody's appealing that decision, whether it's for them or against them. It adds more cost. Sure, insurance companies pay it a lot, but that's how they justify raising our premiums. This is a bad deal for West Virginia. And the ironic part is, the main group that gets benefited by this is the insurance companies, because they benefit from delay, from delaying small businesses who have insurance claims, from delaying injured people who need money to make up for lost wages and medical bills. They delay because they're holding on to the money. As I said just the other day, they're making double-digit returns on their money. The longer they hold these litigants' money, the more money they make. And remember, they're operating with vast numbers, 10,000 claims at any one time. But you know, the scariest part of this bill isn't the intermediate court, and I just don't know why we've got workers' comp in the Office of Judges in this bill. It's the governor that wants it. He wants to eliminate the Office of Judges. The Office of Judges is the last place where people who are injured at work have a shot at due process. Insurance companies deny medical treatment. The only place they can go is the Office of Judges. And insurance companies deny medical treatment not necessarily because it's not good medical treatment, but because that's how they make money. The Office of Judges provided really what's the last bastion of any independent thought on workers' comp claims because they're covered by civil service. They get to do what's right. But we're going to eliminate that Office of Judges. And during the committee hearing, we heard from the former head ALJ, and it appears to be a vendetta because the Office of Judges works. There's about 9 of them. They hear around 2,300 to 2,600 appeals. That's a lot for 9 full-time employees. They have assistants that help them with it. They have hearings, they collect evidence. It's a major process. Around 300 of those appeals get appealed to the Board of Review, which right now is a 3-member panel appointed by the governor. Their jobs are beholden to the governor. Now, when you're looking to when you get injured on the job, you give up your right to a civil case in exchange for workers' comp. It's no-fault coverage. And when that workers' comp insurance company says, we're not paying for your physical therapy, not only is it hurting that individual, but it hurts West Virginia because that person may not get back to work. That person may become a further burden on our tax rolls because they're unable to go back to work or have the job that they used to have. Ask yourself this, and I know that in the Finance Committee, the Board of Review was increased to 5 members, part-time, making $125,000 a year. Their job is will and pleasure, dependent upon the governor's appointment and continued good grace. How are they going to make a fair decision on an injured worker's need for physical therapy, need for an MRI, need for a prescription drug, if the political winds blow in a direction that's not favored? $125,000 a year for a part-time job is a pretty good gig, too. Now, we were told that, 3 Board of Review members couldn't hear 2,300 appeals a year, so they were going to get to hire, I think they called them hearing examiners. They're going to be able to hire all the hearing examiners they need. Well, let me ask you, if we've got a system that works and is not broken, why try to fix it with this? Why try to fix it with such a flawed system that we're abandoning every person who gets injured on the job? And it's not just factory workers and coal miners. It's people that work in office buildings. It's insurance salesmen who are driving down the road and get hit by a car while they're on the job. Those are workers' comp claims. I'm sure my friend from Morgan's got a lot of rebuttal he's going to get up and say to come back on this because he believes in it. And I respect that. But the reality is there's no need for this Intermediate Court of Appeals. The reality is we cannot turn our backs on people who work for a living and are injured on the job. They gave up the right to bring a lawsuit in exchange to be treated fairly at workers' comp, with a workers' comp claim. We owe them an independent group of judges who are going to hear those appeals and make the right decision, not the political one. I urge a no vote on this bill, Mr. President.
Is there further discussion? Senator from Cabell.
Thank you, Mr. President. I'm a firm believer that you can change a vote on a discussion like this. I'm going to be brief, and I'm almost always with my chairman on judiciary. However, on this bill, I'm going to break away from him, and I'll tell you why. This bill is not going to hurt trial lawyers. It's going to help people like me that are in litigation over injury cases representing citizens. Because I'm going to raise my fee from 1/3 to 40% because it's an appeal. I'm going to make more money with the Intermediate Court of Appeals and people that do what I do. So if you think you're punishing the trial lawyers, it's the opposite. Number two, the people that are going to be trampled somewhat on this bill are farmers who have an issue with mineral interests, the people that own their mineral interests, landowners. They're going to be worn out with this bill. They're going to pay. They're going to pay their own lawyer. There's no fee shifting. And they're going to finally just sort of give up, and they're going to give in. Small businesses against big businesses. Our small businesses are our backbone. The small businesses are going to be trampled on this bill by big business. Last point. I used to do a lot of family court cases. And I've gone to the Supreme Court on a number of, I once was hired by the government of Iceland to litigate a custody case for one of their citizens. And we went all the way to Supreme Court on custody, and I've done that. What this bill does to the least among us, children in litigation in family court, instead of me needing a hearing before my circuit court judge and walking down a flight of steps at my Cabell courthouse and saying, these kids need their day in court, this custody needs to be litigated now, and getting a quick hearing in front of a circuit judge, they're going into the appellate process. My God, briefing schedules. The cases I've litigated in the Supreme Court over custody, I had a case once that I won, and the kids were 18 by the time that we got our decision. So you're going to slow down the process of justice for our youth in family court. Finally, why are we spending this money? Why are we increasing the size of government? Thank you.
Further discussion, Senator from Ohio.
Thank you, Mr. President. I won't repeat my floor speech from last session or at least I won't go into great detail about my concerns over the lack of criminal jurisdiction with this court, but I do want to mention that we've got corporations and businesses that will get expanded appellate review when money's on the line, but when liberty's on the line, our citizens will not get the benefit of that expanded appellate review. And so I think we need to look at our priorities when we decide how to vote on this bill, and the fact that we're not going to be as concerned about one's freedom as we are with their pocketbooks. And just to follow up on what my colleague from Cabell said related to the fiscal impact of this bill, Mr. President, I really wish we needed this bill. If we needed this bill, that would mean that our courts were bursting at the seams. That would mean that there was a lot of business litigation. That would mean that companies and small businesses and large businesses weren't able to have their cases get through the court system. But that's not the case. Our Supreme Court has told us they're able to manage everything. They are caught up. They don't need to have this extra help. Justice Jenkins did not take a position on it, including the fact that he did not say that we need this court. So, I wish we needed this. That would mean we had more people, more businesses, more activity in our state, but we don't. Our judges are able to manage this. Our circuit court judges are overwhelmed with abuse and neglect cases, so I don't want to fail to mention that. But as far as everything else goes, our courts are doing a really good job of managing things. Let's think about what we could use $8, $9, $10 million a year for. We could use it for kids who are hungry. We could use it to pay our police. We could use it to fix our roads. We could use it to pay our CPS workers. There's so many other things we could use this money for. And I hope that all of you think about that and think about how far $8 or $9 or $10 million would go this year and in a decade. In a decade, $100 million. What could we do with that to better help our state versus creating a layer of the judiciary that's unnecessary? Thank you, Mr. President.
Further discussion before I recognize the senator from Morgan to close debate. Senior senator from the 16th.
Thank you, Mr. President. I got to admit that since this has been around so many years, you get to the point where you feel like, my goodness, if they want it that badly, let them have it. Because every year we fight over this bill. And that was the attitude I had pretty much coming into this. I would ask colleagues, tell me why we shouldn't just go ahead and let this thing go. I mean, for heaven's sakes, let's get it off our docket so we can be focusing on other things. And of course, they say a waste of money and things like that. And I said, yeah, well, we do a lot of that anyhow. But what changed me was yesterday's testimony with Chief Justice Jenkins in Finance. I asked two questions. One, I talked about the intermediate court and said, we're going to be reorganizing your shop, and I know how much you honor the Constitution and the separations of branches of government, the balance of power, and out of respect, I think it's only fair to have you tell us how you want us to rearrange your shop. I mean, judiciary. I mean, surely we don't want to do things to you or for you. We like to do things with you. And at that point, he said, well, whatever you all do, we'll handle it. We'll deal with it. He's not going to be for it, against it. Listen, that's up to you all. But then I also had another question about the drug treatment courts. The adult treatment court, juvenile treatment court, veterans treatment court, family treatment courts. And I asked him, I said, we only have the adult drug treatment court in 23 counties. What would it take for every county to get one of these? He said, Senator, money. Takes about $100,000 per court, and juveniles even less. I think it's in the teens. And then veterans even less than that, and family treatment courts single digit. And I'm thinking to myself, he said, we're looking for federal courts. We need an appropriation from the state legislature. We can expand this. And it works. And Mr. President, I got to tell you, I serve on a drug treatment court, treatment team. Yes, every Monday we meet. And I watch the judges interact with people, and I've witnessed firsthand the transformation that those courts do for the people that otherwise would have only been locked up, their families would have suffered, and they would have never gotten better. I've witnessed the transformation that these courts do in the state of West Virginia for the people. Folks, that changed my mind. This bill is needed not for the intermediate court. This bill is needed for our treatment courts throughout the state of West Virginia. Let me tell you something, what's going on. Right now, if you think about the world and how the world changed, our country and even the world changed on 9/11. Drastically changed the way we looked at the world, the way we reacted to the world, the legislation that came out of it, heck, Homeland Security, other aspects of it. 9/11 was a one-day event, impacted 3 geographical areas, New York, D.C., and rural Pennsylvania. Hundreds of people died that day. Changed the world. Now we have a COVID-19 pandemic going on now for 10 months, longer, going to be a year here soon. Every geographical place in the country and the world's being impacted by this. Every human being is being impacted directly, some more than others. And the amount of people, although it goes up and down every day, but there for a while it averaged, the amount of people that died on 9/11 die every single day in America because of this pandemic. And then under this pandemic is another pandemic. It's the overdose. It's the drug use. It's the alcohol. Our families are being decimated, that we have a pandemic within a pandemic, and in a post-pandemic world, we're going to have to address that pandemic. Once we get our mask off, there's going to be a huge pandemic in front of us of the aftermath, and the world is going to be a different place than we have ever experienced in the post-pandemic world for COVID. Mr. President, we allocated $2 million in this body right before we left, thinking that that would take care of our COVID pandemic if it ever came, and it hit us pretty daggone hard. Fortunately, the federal government came in. We've been able to continue to work through this as we're still in it. Mr. President, I would ask for your leadership to take this money, and if we're going to help the Supreme Court reorganize, instead of doing it for special interests, other interests, whatever, let's do it for the people of West Virginia, and let's put this money into drug treatment courts, juvenile drug treatment courts, the veterans treatment courts, the family treatment courts, and let every county, every community in the state of West Virginia have access to these resources, to these opportunities to build these lives back from this pandemic, to recover what's underneath of us. Folks, we have to get our priorities straight here. We have a major issue that we have to address, and we got a vehicle to do it, but not through the intermediate aspect of it, looking for insurance and all this other stuff. We could actually help the Supreme Court expand their treatment courts all over the state of West Virginia and make it available to every community, every family, have those family treatment courts, rebuild families, rebuild West Virginia, so that people will want to stay, come, work, and live and be happy here. And once again, we have community of common unity within our society. Mr. President, for that reason, I would ask that we reject this bill, and let's go back and use the money that's been identified, and let's give that Supreme Court the resources and the opportunity, and give our people a chance to be able to recover from this COVID-19 pandemic, to rebuild our state, recover from the pandemic of the drug and overdose and addiction epidemic that's underlining it, so that we can go forward and be prosperous, productive, and happy. I ask the rejection of this bill, Mr. President.
Further discussion. Senator from Morgan to close debate.
Thank you, Mr. President. I'd like to begin by addressing some of the comments that were made about the bill or the consequences of the bill during the course of the debate, because I think some of them are fundamentally just incorrect and misunderstandings. First of all, it was suggested in debate that creating an intermediate court of appeal will increase the cost of litigation. I disagree with that completely, Mr. President, and I think the exact opposite is true. Here's why. Appeals will move faster, and appeals, instead of coming all the way to Charleston, a case that has to be appealed out of Hancock County or Jefferson County could be appealed to an intermediate appellate court that sits in the Northern District of West Virginia. A case that is appealed out of Circuit Court of Cabell County or Wayne County, Raleigh County, can be appealed to an intermediate appellate court that sits in the Southern District of West Virginia. The courts will be closer to the people in that regard, geographically. I don't think there will be additional cost in litigation for that reason. Appeals will move faster. That's why I think this bill, we create an intermediate appellate court, will be good for injured plaintiffs and defendants, for farmers, for mineral owners. Their cases will be able to be reviewed faster and closer to home. I think it will expedite the Supreme Court's docket with respect to those critically important cases that we talked about, criminal cases, abuse and neglect cases. The senator from Ohio spoke eloquently about how important those cases are, and he's 100% correct. Let's agree that a case wherein a person's liberty is at stake, he or she is facing incarceration, or a case where whether a family will be preserved together or torn asunder and a child sent to foster care to be adopted by another family, those are the most important cases that we have in West Virginia. And they stay with the Supreme Court of Appeals. We're not going to process those through an intermediate appellate court. The only appeal in the appeal in those cases will be to the West Virginia Supreme Court of Appeals for a number of reasons. Number one, because they're the most important cases that exist. They're much more important than cases about money or a boundary line, those sorts of things. And they're cases where you need fast decisions. The disruption that occurs in an abuse and neglect case when a child is removed from his or her family is unfathomable. And among the things that we must do, I'm not talking about necessarily how each case turns out, but we have to bring those cases to quick, final decisions, Mr. President, because the life of a child is at stake. Every day when a child is in limbo, not knowing is he going to be returned from foster care to his family, or are the parents' parental rights going to be terminated and he's going to be sent to some place to live to be adopted by another family. Those questions have to be answered quickly, Mr. President, correctly, but quickly, because it's unfair and morally wrong to leave children in that circumstance in limbo. This bill will help with that, Mr. President, because we divert the civil cases to an intermediate appellate court. The Supreme Court will have less on its plate and can focus more fully on those things that we leave directly within the Supreme Court's jurisdiction. There were some comments made about workers' comp, and I must address those. And those comments were, in my opinion, incorrect. When we create an intermediate appellate court, we don't need the 2 levels of review that exist now in the workers' compensation system. So this bill does collapse and consolidate the Office of Judges and the Board of Review. We don't have an intermediate appellate court now. So under current law, the course of appeal is Office of Judges, Board of Review, Supreme Court. We add in an intermediate appellate court, you don't need 2 levels below it. You need 1. And we collapse them both together. You have to have a level at which evidence is taken and a record is developed. And that's where the cost savings are in this bill. It saves a couple of $1 million in that area, which is, if we weren't to collapse those 2 levels, it would be more expensive. All right. Now, I'm confounded always by the opposition to this bill because, and I think, in fairness, I think the debate, a little bit sometimes turns into scare tactics. People talk about special interest or the big insurance company. It always seems to come to that, as if this whole idea was hatched somewhere by an insurance company or insurance companies. That's not where this comes from, Mr. President. We've had, in past years, not now, but we've had scandal with our judiciary. And the last big scandal before the scandal of 2018, before that, you go back about 11 or 12 years, there was, maybe even a little before that, scandal because cases were not being reviewed, Mr. President. People were getting judgments. It doesn't matter whether plaintiffs or defendants, civil, criminal, they weren't being reviewed. People have a right to have their case reviewed, whether they're individual citizens, mineral owners, farmers, or businesses. When a lower court makes a decision, it should be reviewed. All right? And that was not happening in West Virginia, Mr. President. It was not. Only a small fraction of cases, appeals to the Supreme Court, were being accepted and heard, and it became a scandal. And so, in April, it was April 3rd, 2009. April 3rd, 2009. The governor of this state, then Joe Manchin, our current United States Senator, entered an executive order in response to it was public outcry. And he entered an executive order and called for the creation of an independent commission to study the need for reforms in the judicial system in West Virginia. And that was Executive Order 6-09, entered by Governor Manchin in April of 2009. That commission was created, and there were some really talented people. These are not shills for an insurance company or the insurance industry. Let me tell you who was on this commission. Caprice Roberts. Caprice Roberts was a visiting professor of law from the Columbus School of Law and the Catholic University of America and the WVU College of Law. Mary McQueen was president and chief executive officer of the National Center for State Courts. John McCuskey Honorable John F. McCuskey is a lawyer, practicing at Schumann McCuskey Slicer, but a former member of the West Virginia Supreme Court of Appeals. He was on it. Joyce McConnell, who was the dean of the WVU College of Law, did an excellent job there. Joyce is now the president of Colorado State University. Marvin Masters, well-known local attorney here in Charleston, talented lawyer, certainly not anybody that anyone would suggest is a front man for the insurance industry. Judge McQueen, Andrew McQueen, circuit judge here in Kanawha County, was on it. Tom Haywood, a well-known, well-respected lawyer at Bowles Rice here in Charleston, former administrator in Gaston Caperton's administration. Sandra Chapman was on it. She was at the time president of the West Virginia State Bar. Cart Goodwin participated as a member of the commission. Cart, as we all remember, was Governor Manchin's chief of staff, became a United States Senator for a short time when the position became vacant as a result of the death of Senator Byrd. And Sandra Day O'Connor agreed to chair it. Former Justice of the United States Supreme Court of Appeals agreed to chair and did chair this independent commission on the need on judicial reforms that Governor Manchin put together. That commission worked, took evidence, made recommendations. 2009. I've got the final report here from November 2009. You can see it's dog-eared and crinkled, and that's because I have to bring it to the floor with me every year. But I still have my yellow Post-it notes on it. But their mission was to study the need, and this came from the governor's executive order, study the need for broad systemic judicial reforms. And they did. All those super talented, super committed attorneys and experts. And they made recommendations. And I want to spend a little time on those. The commission made a number of recommendations. And by the way, the state, the legislature in particular, adopted many of them. It recommended the codification of an appointment process, a vetting process when there are judicial vacancies. That was one of the commission's recommendations, and the legislature did it. We have it now in code. That wasn't the only recommendation they made that was adopted. They recommended that the state look at establishing a business court, and that was done as well. That was done. It's part of our judiciary now. They recommended, Mr. President, a pilot program on public financing of elections for 2012. That was done. They recommended that the legislature should act to establish an intermediate appellate court. That was not done. And they said, by virtually any measure, the Supreme Court of Appeals is one of the busiest state appellate courts in the entire country. An intermediate appellate court would ease the burden on the Supreme Court of Appeals, free the High Court. Here's the key. This is the whole point of this bill. Free the High Court to continue hearing a discretionary docket focused on important or novel legal issues and expand the core functions of our appellate judicial system. So, this is not Charlie Trump saying this. Sandra Day O'Connor, the commission appointed by Governor Manchin, all those distinguished jurists, practitioners. And I want to get to some of the meat of this. In the, in the recommendations in 2009, in the Commission's recommendations in 2009, which this legislature has thus far ignored as to an intermediate appellate court, the court noted, the Commission noted that 10 years before that, there had been a commission appointed to study the future of West Virginia's judiciary. It was 1998. And it recommended the creation of an intermediate appellate court. So the 2009 commission wrote, and I quote, "This idea, of course, is not new. Over 10 years ago, the Commission on the Future of the West Virginia Judicial System urged the legislature to create an intermediate court of appeals, writing," and this is a quote from the 1998 Commission, "A full-time intermediate appellate court would allow the justices of the Supreme Court adequate time to consider and write opinions that have a defining impact on matters of law and public policy. Moreover, the creation of an intermediate appellate court would relieve the Supreme Court from hearing and deciding routine cases that do not involve unresolved issues of law, constitutional challenges, or public policy." So that is the reason to create, if we will, an intermediate appellate court. It's not to appease an insurance company. That has nothing to do with it. This recommendation was made in 1998, Mr. President, and again in 2009. Now, the 2009 Commission recommended that it should be comprised of a sufficient number of judges, preferably 6 to 9, to allow the court to sit in panels of 3. That's what our bill does. Three judges, each panel, one for the north and one for the south of the state. By using panels, the Intermediate Court of Appeals can dispose of a great number of cases, thereby expediting the appellate process and minimizing concerns of litigants who fear an additional step in the appellate process may create delay. And I agree with this, by the way. I think this will expedite appellate process for everybody if we pass this bill. It recommended the qualifications of judges, and their recommendations are what is in the bill. It talked about selection of judges, suggested that they be appointed initially. That's what we do. Of course, our bill requires them all ultimately to stand for election. They recommended that in West Virginia, citizens should have an appeal as a matter of right. We do not now. Our Constitution does not require the Supreme Court of Appeals to hear every case. They've chosen of late to do so, but it is not a constitutional requirement. Mr. President, our bill would create for every West Virginian an appeal as a matter of right from every decision of a lower court in this state. So while the legislature, the state as a whole, adopted many of the recommendations that came from this commission in 2009, this one it has so far not adopted. Now, part of the reason, that I think that recommendation flowed from the criticism that at the time was true. Cases were not being heard. People had appeals, wanted to appeal decisions of the lower courts, circuit courts, and the Supreme Court would say, nope, sorry, we're not that we don't agree with your arguments, we're not going to hear the case. only a small percentage of cases were heard. Now, it is true, as others have noted, that in, I think it was 2010, and I think probably, Mr. President, in whole or in part, in response to this, the recommendations and report that came from this commission, the Supreme Court changed its rules, and now they do hear every case and issue a decision in every case. Now, there are many measures, many ways by which you could measure how busy a court is. And I read for you from the language in 2009, was recognized by that independent commission that it was among the busiest courts in the nation. And others here have made the point that the total number of cases, petitions for appeal, have dropped over the years, and that's true. But, Mr. President, that is not the only measure, the only manner in which one might measure how busy a court is. And I think this is a more telling statistic. This is from the Supreme Court's website, our state Supreme Court's website. And it's just a list of how many decisions on the merits the court issues each year. And if you go back and look at 2006, 124 decisions on the merits. 2007, 122. 2008, 122 decisions on the merits. Last year, 2020, 895 decisions on the merits. It's been as high in recent years as 1,100. Oh, there's a 1,300. That was 2013. But even now, even though it's dropped off a little bit from 2013, 2014, you have a court that is more than 5 or 6 times busier than it was in 2008, which would have been the data that this commission examined when it determined it was among the busiest courts in the nation then. So, you know, we have in the East Wing, the citizens of this state have elected what I think is an outstanding Supreme Court of Appeals. I think that the Supreme Court of Appeals we have seated now in West Virginia, Mr. President, is as talented as any this state has ever had. And so why would we not want them to devote their talents to the most important cases we have, criminal cases where people's liberty is at stake, abuse and neglect cases where the future for children and families lies in the balance, and then go back to a discretionary docket, civil cases, other cases. They can take those which involve cases of moment, cases of great public interest, cases of challenge. We provided in the bill a mechanism, even not even for those to have to be appealed, but they could lift them upon motion right out of the intermediate appellate court, cases of exigent circumstances. This talented group of justices, as I said, I think as talented as any Supreme Court in the history of this state, should be liberated, as that commission in 2009 said, not to address routine matters, but to focus its efforts and attentions to the optimization and utilization of their talents, the development of precedential law in West Virginia. Now, it is a false argument to say that it's either this or all these other things. You know, I agree with expanding treatment courts, that's been discussed, but these are not mutually exclusive options, Mr. President. This bill, if enacted, will create an intermediate appellate court that this state needs, that has been recommended to us by experts over decades and generations. It will expedite, not delay, the appellate process. Mr. President, I would like to close by thanking Governor Justice for his leadership on this issue. This is a governor's bill we have before us here, and it's good policy, and I urge the passage of committee substitute for the committee substitute for Senate Bill 275.
Question before the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, there's 19 yeas, 15 nays, and 0 absent and not voting. More than a majority of those present and voting have voted in the affirmative. I declare the bill passed. The clerk will communicate the action of the Senate to the House.
Engrossed Senate Bill 296, relating generally to repealing certain rules. Third reading of the bill.
Question is on passage of the bill. Senator from Morgan.
Thank you, Mr. President. Apologize, I made a little bit of a mess over here. Senate Bill 296 is a repealer bill. We asked multiple years ago, we started the process of asking agencies of the executive branch of the state government to send us lists of their rules which are obsolete, no longer necessary, and this bill is one of those. By that method, we've taken hundreds and hundreds of sets of rules off of our books and shrunk our Code of State Regulations. This bill will repeal 30-some, I'm looking for the exact number here, a number of sets of rules that are listed in the bill, but that have been determined by various agencies and bureaus and departments of the state government to be unnecessary now and obsolete. Mr. President, I'll be happy to try to answer any questions. Otherwise, I urge the bill's passage. 16 rules. 16 rules.
The question is on passage of the bill. Is there discussion? If not, the question before the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, 34 yeas, 0 nays, 0 absent not voting. More than a majority of those present and voting having voted in the affirmative. I declare the bill passed. The clerk will communicate the action of the Senate to the House.
Engrossed Senate Bill 372, providing greater discretion to West Virginia Board of Medicine to approve graduate clinical training. Third reading of the bill.
Question is on passage of the bill. Senator from Marshall.
Thank you, Mr. President. This bill permits the West Virginia Board of Medicine and discretion when considering additional criteria in determining whether an applicant has successfully completed graduate clinical training. Currently, in order to satisfy these criteria, an applicant must complete a program which is approved by the Accredited Council for Graduate Medical Education. This bill provides that the board can determine the applicant has met the criteria for graduate clinical training when an institution that sponsors or operates a residency program in the same clinical field or related field is approved by the Accreditation Council for Graduate Medical Education, or at a time when accreditation was not available for the fellowship's clinical field, and the board determined that training was substantially equivalent to the accredited training due to the objective standards, the board could issue a license if all other criteria are met. That was a mouthful there. And this statute also permits the applicant also use a fellowship training in combination with board certification to meet the qualification for licensure. That was very complex, but basically, Mr. President, there are. I just want to be clear here. There are a lot of bills that are getting press concerning licensure stuff, and this is not a bill that is looking to decrease the qualifications for licensure. All this board does is, in a few certain circumstances or instances, allow our West Virginia Board of Medicine discretion in evaluating these few instances on an individual basis because they're all different. Mr. President, I urge passage.
Question is on passage of the bill. Is there discussion? Senator from Boone.
Thank you, Mr. President. I rise in support of this legislation. It's supported by the Board of Medicine. It will allow for better access to specialty care in places across the state, and again, the ultimate winners will be our patients' access to care. Urge adoption.
Is there further discussion? Junior Senator from the 8th.
Yes, Mr. President, I rise in support of this piece of legislation as well. I think the chairman of the committee has done a great job of bringing this particular issue to the attention of the chamber. I think it addresses a need, and I appreciate his work and the committee's work on this bill. Thank you.
Further discussion? If not, the question before the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, 34 yeas, 0 nays, and 0 absent and not voting. More than a majority of those present and voting having voted in the affirmative. I declare the bill passed. The clerk will communicate the action of the Senate to the House. Bills on second reading.
Committee substitute for Senate Bill 7, limiting political activity by public employees. Second reading of the bill.
The question is on adoption of the amendment offered by the senator from... Are there amendments to the bill?
Yes, sir. Senator Trump moved to amend the bill on page 2, section 2.
Question is on the adoption of the amendment offered by the senator from Oregon. Is there discussion? Senator from Oregon.
Thank you, Mr. President. I request unanimous consent to withdraw the amendment that was offered yesterday.
Is there objection? Chair hears none. So ordered. Are there further amendments to the bill?
Yes, sir. Senators Romano and Trump moved to amend the bill by striking out everything after the enacting section.
Senator from Oregon.
Thank you, Mr. President. I request unanimous consent to explain the amendment in lieu of having it read.
Is there objection? Chair hears none. So ordered. Senator from Oregon.
Thank you, Mr. President. The members will remember when this bill reached second reading yesterday, the senator from Harrison raised some really good points. And so what we've done is reformulated this together in a way that makes it clear that while the elected members of the Board of Public Works are exempt, there's a proviso in it now that says they have to make clear and announce whether they're on official duty or they're on campaign duty or political duty when they are engaged in activities. We deleted, our amendment deletes the exemption for legislative employees. And for a couple reasons, but number one, and this was brought up, I have to compliment my friend from Harrison County, raised the issue. Upon further investigation, Mr. President, we learned that there is an advisory opinion already that's been issued by the Ethics Commission that says legislative employees can do political activity on their own time, but but that's it, and it's a violation of the Ethics Act for them to do it on public time, and by exempting them as we had in that, the way it was before us yesterday, I think it would have created an inconsistency within the Ethics Act, and I want to thank my friend from Harrison County for bringing that to our attention. So I would urge the adoption of our joint amendment.
Is there discussion? If not, the question before the Senate is the adoption of the amendment offered by the senators from Harrison and Morgan. All those in favor will say aye. Aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the amendment adopted. Are there further amendments to the bill?
No, sir.
The bill will be engrossed and advanced to third reading.
Committee substitute for Senate Bill 42, creating Zombie Property Remediation Act of 2021, second reading of the bill.
Are there amendments to the bill?
Yes, sir. Senator Swope moved to amend the bill by striking out everything after the enacting clause.
Senator from Mercer.
Thank you, Mr. President. I request unanimous consent to explain the bill in lieu of having it read.
Is there objection? Chair hears none. Senator from Mercer.
Thank you, Mr. President. This amendment clarifies some language addressing mortgagees. It does not change the purpose of the bill. I will answer questions, but I urge passage of the amendment.
Is there discussion? Senator from Cabell.
Thank you, Mr. President. Let me just say thank you to the Economic Development Chair for bringing this bill forward literally on the first day of the committee's meeting. What we had was some pretty energetic work on the behalf of the bill by the senator from Brooke, who reached out into his community to get good ideas. The junior senator from the 17th gave us some good things to think about to improve the bill. The senators from Summers and Logan convinced us that this needed to be expanded to the counties to give the counties that opportunity. And the senior senator from the 8th and the senator from Boone. So there was a lot of collaboration. I'm very comfortable that the bill is much better now than when I introduced it, and I urge passage.
Some further discussion. Senator from Harrison.
Thank you. Will the gentleman from Cabell yield?
Will the gentleman yield? Gentleman yields.
I'm not sure.
Senator, I didn't realize this was your bill. Could you tell me, and I've looked through it, this is the first time I've seen it, are counties included in this, or is it restricted to municipalities?
The introduced bill would apply only to municipalities, but after some input from the county commissioner from Summers and the senator from Logan, we incorporated counties to the extent that counties will not be duplicating a program that a municipality has. The municipality will control the dilapidated housing, abandoned housing, or other structures, not just limited to housing, but the municipality will have, if they want to, a program existent within its borders, and then the county will have jurisdiction if it desires to implement a program like this for the part of the county not within the municipality.
I just couldn't find the bill you're confident it's in there, though.
That may be in the new language in the amendment. I don't recall whether we did that in the committee or it's contained in this, but I can assure you it's in there.
Okay, that's all I need, because I just couldn't find it. Thank you, Senator.
Yep.
Is there further discussion? If not, the question is the adoption of the amendment offered by the senator from Mercer. All those in favor will say aye. All those opposed, no. The ayes appear to have it. The ayes do have it. I declare the motion adopted. Are there further amendments to the bill?
No, sir.
The bill will be engrossed and advanced to third reading.
Committee substitute for Senate Bill 53, providing person criminally responsible for another's death may not be involved in burial arrangements.
Senior Senator from the 17th.
Thank you, Mr. President. I request unanimous consent that the bill lie over one day while retaining its place on the calendar.
Is there an objection? Chair hears none. So ordered.
Senate Bill 396, providing limitations on nuisance actions against fire department or EMS fixed sirens. Second reading of the bill.
Are there amendments to the bill?
No, sir.
The bill will be engrossed and advanced to third reading. Bills on first reading. Senior Senator from the 17th.
Thank you, Mr. President. I request unanimous consent that all bills on first reading be considered read a first time and advanced to second reading.
Is there objection? Chair hears none. So ordered. Introduction of guest. Remarks by members. Senior Senator from the 6th.
Thank you, Mr. President. It's that time of year again. You all have heard my passion for OHVs. Again, that's off-highway vehicles. I'll try to keep this short. Keep in mind that OHVs are not only vehicles that are meant for off-highway travel, but there's many other vehicles that fit under that moniker. Let me tell you a little bit about my impression of West Virginia, what was going on, and what I thought I could do when I got here to the Senate. When I was elected, I thought, wow, West Virginia doesn't know about the potential for embracing the OHV industry. I knew how this state was blessed, and I knew it had the OHV world at its grasp. So I started introducing bills, thinking that's all it would take, and we'd be on our way to being a national leader. But right off, I saw pushback, seeing how my bills that thought outside the box got defeated nearly every time. Every year I tried different strategies, making a little progress each year. I've made so many connections with people in the hobby across the nation, big-time national players in national organizations, and good people here in our state that have the same goal as me, to promote West Virginia, give our residents and visitors fair access to our public land, and draw attention to our great trails that only the locals know about. Many of my fellow senators and delegates have participated in the West Virginia Legislative Trail Ride for the last 2 years. Last year's ride drew 167 Jeeps here to the Capitol for the rally. From these events formed a casual group of enthusiasts that have taken on the task of educating West Virginians about the importance of land access. There are 2 representatives of the West Virginia Jeep Club, Nico Bowden and Vince Lucas, Josh Webb from the 304 Jeep Club, Brian Holmes representing the Dual Sport Adventure Bike Group, and Eric Larch, a local business owner that turned his passion into his business by creating Mountain Made Off-Road UTV shop. And last but not least, Jerry Bain, who represents a full-size off-road segment. That probably was the most important aspect of the group. After last year's Jeep rally, Jerry set up a weekly conference call, built a social media page, and tied these key members into dealing with issues that face our hobby and industry. They called themselves the West Virginia Off-Highway Vehicle Coalition, and they tackled issues with overreach of local governments last summer with the misinterpretation of Senate Bill 690 from last session, and have been proactive in supporting ideas to promote responsible use of our public land in West Virginia through fighting road closures, illegal gates, and working with the Department of Highway on mapping issues and many other issues. So this group, in the face of COVID, wanted to show support they have in West Virginia to the legislature and state agencies, and just how big of a deal this is to them and fellow West Virginians. They will be gathering at their now annual OHV rally at the Capitol this Saturday from 10 to 1, of course practicing social distancing. I know many of you will be out of town, but if you are in town, please stop by and see the impact of this basically untapped resource to West Virginia's economy. There will be guest speakers starting around noon, and a special announcement from Director Stephen McDaniel of the West Virginia Department of Natural Resources about their involvement in an OHV project, and a good special announcement. There's a flyer on your desk with all the details, and I would like to tell you all that this will be the last time I talk about OHVs on the floor, but I probably can't say that's probably not the case. But thank you, Mr. President.
Junior Senator from the 8th.
Yes, Mr. President. I will try to be brief. It truly is an honor to serve in the state Senate. We are very lucky individuals to be here. I've always believed that. I've always thought that. And I believe that today we are, in a sense, princes of the realm in that regard. I've been here, this is my 3rd session. And last night was the first time that I walked out of here, out of this building, angry and infuriated. I hope it's not an indication of things to come, and I don't think it is, but that's my concern. Now, before I say anything else, I want to say this, that what I'm about to say, I make no quarrel with people who voted for or against a bill. They have their reasons. That's what we're here to do. And what I'm about to say is no reflection on our chairman of the judiciary. I'm happy to say that, and I hope it's no offense to anyone else, he's the best chairman in this body. I appreciate the deliberative process. But last night, we worked on a bill in judiciary, an animal cruelty bill, that sought to make intentional conduct, intentional torture of an animal, felonious. I'm not a sponsor of the bill. I supported it in committee, and it failed. And again, I'm not here to talk about the merits of that bill. But my observation was this. We spent 2.5 hours on that bill because some members either could not or would not grasp what it means to be intentional, what it means to be reckless, and the difference between those two terms. And the reason why I was angry is this, that this body passed a COVID liability bill that immunizes intentional conduct, that immunizes individuals who intentionally expose their employees, their consumers, or their patrons to COVID. We spent half the time discussing that aspect. And I think it's important for the people of West Virginia to hear that, and I think it's important that as we move forward, we give as much concern and consideration when we're talking about these bills. One that affects everyone, individuals, and the other that affects animals. So I thank you, Mr. President.
Further remarks? Miscellaneous business. Senator from Upshur.
Mr. President, I have filed a voting sentiment with the clerk.
The clerk will read the voting sentiment.
Had Senator Hamilton been present in the chamber on Monday, February 22nd, he would have voted yea on the passage of the following bills: Senate Bill 66, Senate Bill 69, Senate Bill 280, Senate Bill 293, Senate Bill 295. He would have voted nay on the passage of the following bill: Senate Bill 11.
Senator from Upshur.
President, I ask unanimous consent that my voting sentiment be recorded in the journal as reported.
Is there objection? Chair hears none. So ordered. Senior Senator from, 1 second. Senator from Harrison.
Thank you, Mr. President. I ask unanimous consent that the remarks of the senator from Kanawha be included in the appendix of the journal.
Is there objection? Chair hears none. So ordered. Senior Senator from the 17th.
Thank you, Mr. President. Pending announcements, I move the Senate stand adjourned until tomorrow at 11 a.m.
Are there announcements? Senator from Morgan.
Thank you, Mr. President. Your committee on the judiciary will meet today at 4 p.m. in the Judiciary Committee Room in the West Wing, 4 p.m.
Senior Senator from the 4th.
Thank you, Mr. President. Your Committee on Finance will meet today at 4 p.m. in room 451. We'll have a budget hearing with DHHR. We will also have a Finance Committee meeting tomorrow at 9:30 a.m. in room 451M, where we will consider SJR 4.
Senator from Preston.
Thank you, Mr. President. Your Committee on Agriculture will meet today at 3 p.m. 208 West.
Senator from Mercer.
Mr. President, your Committee on Economic Development will meet today at 2 p.m. 208 West.
Junior Senator from the 17th.
Yes, thank you, Mr. President. Your Committee on Pensions shall meet today at 3 up in the Senate Finance Room. We have one originating bill to.
Are there further announcements? If not, the question before the Senate is the Senate stand adjourned until tomorrow at 11 a.m. All those in favor will say aye. All those opposed will say no. The ayes appear to have it. The ayes do have it. I declare the Senate adjourned.